And so in the court right now, that's sort of my area. Like each of the judges have divided up a service, and that's the service that I'm the one that's more hands-on with.
Interesting. And Alexandria, how do you specialize in this?
I've been an attorney for 37 years, and my entire practice has been in domestic relations court and juvenile court, doing domestic relations cases for domestic violence victims, both divorces, civil protection orders, custody cases. And I've done that my entire practice.
So let's start out with the big question. What really is domestic violence? Can you explain that?
It is a pattern of power and control. One uses power to gain control over the other.
Physical and emotional?
Physical is just one piece of it. Emotional, psychological, sexual, coercive, controlling behaviors. What's interesting is there's both a social and a legal definition. And the social definition broadens domestic violence to the financial, to the coercive control, to the psychological, to the emotional. The legal definition limits it to sexual, stalking, threats to hurt or kill, or attempting to cause or causing bodily injury. Or committing an act with respect to a child that results in that child being abused. But in any case, the one thing we can say, it is not random, it is not mutual, and it is not isolated. It is a pattern.
What do you mean by it's not random?
It doesn't, it isn't that somebody just goes off and hits somebody by accident. Or you and I are fighting, we're married, let's say, and I throw the keys, or I do something like that. That could have been random, but it doesn't happen over and over again. So, when I say random, I mean people who just every so often do something. That is not what I'm talking about. I'm talking about classic domestic violence, which is the pattern behavior.
We're not allowed to hit the table because it goes off the microphone.
Which is that pattern behavior where one intimate partner uses that to control the other.
So you're saying it's an intentional act. It's I'm going to hurt you
it could be
to
intentional,
take control.
It could be reckless. It could be either one of those. And it could be a subjective belief that the survivor or the victim believes the other person is going to hurt them based on a past history.
So as far as the domestic violence legal aspect of what they deal with the court, you're saying it's strictly physical?
No, I'm saying physical. I'm saying threats to hurt or kill. I'm saying stalking behavior. I'm saying sexual violence. And I'm saying committing an act with respect to a child that results in that child being abused or
So we deal with
neglected.
the physical, I don't want to say, physical harm is what they're trying to avoid. You can't go in there and say, my husband won't let me control.
No, not in and of itself. If you're, that is one aspect.
It's part of the
additional
psychological,
piece. Yes.
social definition and part of what happens, and it's invisible. You can't, a black eye, everybody can see. But that for the legal, to have the protection legally, you have to have something more than.
So you have to either
threat.
attempt to cause or recklessly cause some type of bodily injury. Now that's determined to be of the body. It can be a person by threat of force who puts another in fear of imminent serious physical harm. And what's interesting is the physical doesn't have to happen all the time. If I hit you 3 times and we're married, and then I raise my arm, that could be enough because you will already have known that I could hit you again. So the threat is just raising my arm, and I say nothing.
So in what cases would a court issue a protection order? And maybe this would be good for you. Can you talk about protection orders and how they work? Say we did have that scenario, married couple, somebody gets hit.
Maryann,
I'm sorry.
can I come back real quick?
Uh-huh.
I guess we jumped right into it, but you help individuals, females probably mostly.
I help
Present their
victims of
case.
domestic violence who need divorces or protection orders stay safe. And we assess what they need. And sometimes they need both, sometimes they need one. And we go through that. Sometimes if they're not married, they may not be able to get a divorce. Well, they can't get a divorce.
So
we do the assessment to see what can we do to help a survivor of domestic violence remain safe.
And that's through the Legal Aid Society.
Through the Legal Aid Society.
And I'm sorry, we're jumping back real quick. Now, the Legal Aid Society is what, the 5th largest
in the country.
In your website,
Really?
let me say this: the website is www.lasclev.org.
Yes.
And that goes through all what you guys do.
And
you can also donate through that website.
Absolutely.
Correct?
And we represent a part of Northeast Ohio. We have offices in Elyria, so we represent Lorain County, Cuyahoga County, Lake, Geauga, and Ashtabula.
Now, Judge, then on the flip side, your group, magistrates and judges, actually hear the cases and decide whether there's going to be a protection order filed, correct? Okay, and I just wanted to, for the audience that didn't know the rules of what they do.
Sure.
And legal aid, of course, has a dollar limit, so an income level, is it 116% of the poverty level?
No,
or
we can go up to,
150%?
we can possibly, depending on if they're victims of domestic violence, go up to 200% in certain circumstances.
So lower income.
Lower
Very,
income,
yes,
right.
low income.
And I apologize.
No, you're
what
fine.
What was your question before?
I think I lost it. But
You were going to ask the judge,
Go back to it.
what does it actually take to do it?
Yes. So say that scenario came true. A man and a wife have an argument. There's physical violence. What's the next step?
Client would come in, or she would go in pro se and go to the domestic violence department. She would tell her story. She would write out that story in a statement. She would have to show that she is what's called a family or household member under the statute. And then if she is a family or household member, and in our case, if she's a family or household member and she is within our federal poverty guidelines, then we would help her prepare the papers for a protection order. The papers are standardized forms that the Supreme Court Forms Committee, Advisory Committee on Domestic Violence, created, and those forms have been adopted and approved by the Supreme Court. So we use those forms. Client really tells her story, and then we go to court now.
Yeah.
Right.
Yeah.
So
Your
I guess
turn.
the court judge, what happens?
So one of the things that has happened in the last 8 years or so, for 14 years we've had a dedicated magistrate and a person who helped the self-represented people who came in. Again, you have to understand that we cannot practice law for somebody. We can only give information. However, what happens, our department has expanded from 2 people to I think 11 people right now. So when somebody comes in, at this time, if it's intimate partner violence, then they are assigned an advocate from the Domestic Violence and Child Advocacy Center. We have 2 advocates who work full-time in our building, but they work for the Domestic Violence and Child Advocacy Center. So if it's intimate partner violence, they then help that person. They talk to them. They do a lethality assessment. Are you
A what?
a lethality
what is that?
assessment? So this is something that's really important for people to understand, and there was a lot of talk about it after Aisha was murdered.
Right.
So here's what it is. Several years ago, a psychologist in Maryland developed, Dr. Jacqueline Campbell developed this questionnaire, and it's used with first responders, basically police going to a domestic violence situation. And it's just some simple questions which alerts the person to the fact that they are in danger of being murdered, and alerts the first responder, because when you are called to a situation over and over again, or similar situations over and over again, sometimes you just don't see the urgency of it. And so the lethality assessment has been expanded, and now there's the one form we use, I think, has about 20 questions.
Is this online? Is there, you could find these questions online someplace?
Yes, you can.
Yes.
But they are...
They're weighted, and you have to be trained to give it and to understand the weight.
But like some of the questions are: have you ever been strangled? Do you have access? Does he have access to weapons? Has he been stalking you? Is he obsessive? Did he beat you the first time while you were pregnant? So all of these things. Is he unemployed? All of these things would be high risk for potential fatality.
And they're not necessarily something intuitively you would understand. Does the person have a firearm? Okay, you sort of get that. But do you have a child from another relationship? It's one of the questions, and people wouldn't necessarily think about that, but if you do, it's another person competing for attention, and worse, in the mind of a batterer, it's proof that your significant other has been with another man. That's assuming that the gender's man and woman. But again, the questions can be presented neutrally. Although some of the versions of it have the he's and the she's in there. When our advocates use it, it's done more neutrally. But it's really important coming in that people understand this is an education tool, that they understand that they're at risk, because this is their life, and they may not be aware of that lethality, that's going to happen, because that's just sort of, maybe they grew up in a household where there was violence, maybe they've always had violence in this relationship, and
it's the norm.
It's become the norm, right? And so it's to educate people, and then planning occurs, and that was what Alexandria was talking about with her cases. Sometimes it isn't safe to get the CPO. Sometimes it's better to do something else. Sometimes, you do the CPO and you don't do the divorce. Sometimes you do the divorce first and you wait and see if you need to do the CPO.
And there's a lot of different things that go in there, like health insurance concerns.
Right.
Well, all
medical.
of those, but let me just add one other thing. Sometimes when Diane says it's not safe to do the protection order, that's a big piece. We have to analyze that. If she is living in a shelter, she's undercover, and she comes in to get a protection order, and there are children, he may need to know where she lives because of the children. So we want to keep that survivor safe at all costs, whatever it takes. So that's why we weigh each case separately and each case individually to determine what does this client need at this time.
If a pro se litigant goes in, or a self-representing litigant goes into the Advocacy Center for Domestic Violence at your court, how would they know this information?
And that's exactly why we have the domestic violence department.
Does somebody looks over their report and they assess it for them?
So
through the Legal Aid Society, the Legal Aid Society does that. You can go in and file for a protection order.
Well, no, they would go in. They would go through intake. If they qualify, meaning they're a domestic violence victim, and they are within our federal poverty guidelines. They're assigned to the family law unit. We go through the cases. We determine which cases we can take. And then we bring the client in, and then we do a specific assessment and an application. We make sure that it fits the domestic violence statute, so it has merit and legal sufficiency. Then we bring the case. But as Maryann said, there are many cases where they go right into the court, and that's their first line.
Yeah, would the magistrate or judge be, she's obviously, or he is obviously educated enough to, you guys brought up a good point that I never actually heard. Sometimes it's good to not have a protection order because there's other options. First, I ever heard of this. So who would the magistrate or judge?
Into our department, the department has multiple people working there, and this is the point. We have a case manager. We have the director and the assistant director who help with doing a consent entry sometimes, and there's other people who do intake, and then we have these advocates who don't work for the court but physically have an office in our court, and that was part of the thing that we created when we received federal grant money.
Okay.
So under the first grant, we added an advocate and a case manager, and the department sort of doubled, and then it pretty quickly, it's kind of geometric. It doubled again a couple times.
Well, let's say they qualify and they pass all of those tests. Could you tell us a little bit about, they've passed, they file. What's the next step? I know about ex parte hearings.
Our process is to some extent automated, and it used to take many hours for the person to come in, and that was a discouraging thing. And their clerk of courts used to be across the street. So now we have a satellite clerk's office in the building. We have people who will help with the paperwork. We have an automated system so that they create a statement, right? And then somebody in our department actually types in the documents, because as Alexandria noted, there's forms that we have from the Supreme Court. And then those are, I think they're electronically sent to the magistrate
They're also
now.
online too for
Yes,
those, or for
yes.
those
So people can
requests.
take a look at them at home and try to work on them.
And they're both on the domestic relations website,
On our
as
website,
well
yes.
as the Supreme Court website. But from a legal standpoint, there are two hearings oftentimes. There's an ex parte hearing. So when that
Which means
that client goes in without the other
themselves.
side. There's not another side. So it's based on what the allegations that client says. So that, let's just say pro se. They go to the domestic violence department. They say they're victims of domestic violence. The people at the domestic violence department, they help them fill out their papers, they fill out a statement, the domestic violence department makes all the copies, gets it filed, and then they are probably going to have an ex parte hearing. So they go before a magistrate and they tell their story. There's nobody there to say, right, nobody there to contradict, so they tell their story. So then the court has to say, is there by statute, is there an immediate and present danger to believe that domestic violence was committed? And there was some act of domestic violence as I defined it. And are you a family or household member as defined under the statute? Yes, I will grant your ex parte. And by law, we set the second hearing within 7 or 10 days. That hearing is for the respondent. That is that respondent's hearing to come into court and either agree to the terms of the order, which would be a consent entry, not show up, which means then that same magistrate will hear it on a different level, hear the case again. If they believe it took place and they believe that there was this person was a victim of domestic violence, the act took place and that victim is in danger of further violence, they will grant the protection order for a date certain, but not to exceed 5 years. If, on the other hand, that respondent shows up and wants to dispute the allegations, then there could be a trial where both sides testify.
So let me get this straight, or explain for people that don't really know. The petitioner is actually the person that says, I'm a victim, I filled this paperwork out for a hearing.
Right, for the protection order.
And the ex parte hearing is, listen, there's no time to wait to schedule a hearing for the alleged abuser to come in.
Right.
I need something immediate, correct?
Yes, that's true.
Okay, so they have this hearing and say, if it's granted, it's granted, and then they have a sheriff, is that right?
Send out service.
To go serve him or her as soon as possible to say, stay away from this person, right? Then you were talking about they schedule a hearing.
So the hearing by statute also has to be 7 or 10 days, and there's a difference on why it's 7 or 10 days. But again, that's pretty quick, and it needs to be because you're taking somebody's rights away. You might be putting them out of their house,
Or taking away their kids,
something. So those hearings happen pretty quickly, and they're, by policy, we don't continue them, that is, move them back unless the respondent requests it.
And then the respondent is the alleged abuser.
Right.
Right. Okay.
So that we don't let the petitioner kick it so that there's an order on for a long time. Now, if the respondent doesn't get served or dodges service, then the order stays on until that person is served, and we can then have the hearing.
Okay.
I want to take you back just a little bit, just because I've heard stories. If a self-representing person goes into the domestic violence center to fill out a petition, and
you're talking about the domestic violence department at the court, or
that's
the
correct.
domestic violence center?
At the court.
At the court.
And they sit with an advocate. Does the advocate or anybody have the right to tell them no before the judge reads their petition?
They will tell them. I think at some point jurisdictionally they might say no, because we don't have jurisdiction over people who aren't family or household members or in a dating relationship. And so jurisdictionally, sometimes people come to the wrong court, and it might be a stalking case, but it's stalking with a stranger, and they need to be at common pleas court. So the only people who are told no are that you're not in the right court. And if you go forward, it's going to be denied, not because you don't necessarily have a claim, but because you're in the wrong court.
But can I just add, the reason that these cases may be denied would be only for jurisdiction, because the advocates can't practice law without a license, so they cannot sit there and make it.
But I have heard
it's not necessarily the advocate who's saying that; it's probably somebody from the court.
And that's why I'm asking, because I wasn't there with these people, so you don't know if they're telling me the truth or
they don't necessarily know which person's which. You have a large room with a lot of little offices and people coming and going, and they don't necessarily know who's telling them which person said what. But again, if it's not the right jurisdiction, there's no point in having people go through the hearing. And worse than that, they're notifying that person that they're doing this, and they're doing it in the wrong place, and that might elevate their danger.
Right.
Let me ask you, because a lot of people say, "Oh, if you're not married, juvenile court. If you have a child together, it's juvenile court." Does domestic court in domestic relations cover? I just have a child with this person.
Yes.
I've never been married. Because some people get confused, like, well, I was never married. Why would I?
Yeah, that's a good question.
That's the jurisdiction we have.
That's fine. I just want to make sure people understand that, so they're not going like, I can't go to domestic court because I was never married to the guy.
So Alexandria said at the beginning, but I think it bears saying again that our jurisdiction is people who have family relationship, which could be by marriage.
Spouses, former spouses, persons living as spouses, which are people in a cohabiting relationship.
And by cohabiting, I mean you're just living together and dating.
Right.
Well, you're living together. You share some degree of commitment. You share familial or financial responsibilities.
Or you never live together, but you have a child together, which is the classic juvenile court situation. And then last year we added this dating violence, which it's a relationship, not fraternization on a business level. It's something more than that, and within the last 12
intimate and
months.
romantic nature.
So is this in a what is this, a new policy? How did that get thrown in?
New statute.
Really?
House Bill 1 went into effect.
When did it pass?
Last year.
Oh, I missed that one. That's a good one. That's a very good one.
Before, the case law basically covered it. You either were covered in our court or you were covered in the common police court stalking. So the case law sort of did it, but it wasn't called that. And so this way it's
so
out
for
there.
those people, but again, there's still a lot
but there's a relationship there.
You have to have a relationship. It's not just anybody. And then there's questions.
Right.
Let's say you're dating by way of social media. You're on Tinder, and then that person hurts you. There's a big question: what is dating? So I think over the next 5 years, you will have case law that will help determine how to interpret that dating relationship.
Because Tinder would probably go criminal, a different court, right?
Has there been a lot of case law coming out regarding that standard dating?
No, not yet.
Nothing yet.
I know because I write this.
Well,
You do it all the time.
speaking of internet dating, I mean, that brings up, how much domestic violence do you hear about with online dating?
Is it mostly stalking?
I think it's mostly in the stalking context, or the social media, the text, the screenshots, all of those things. But I think what we're learning is stalking used to be following, watching. Now stalking is repeated text messages, repeated phone calls, GPS monitoring, some type of in-your-face posting of pictures or something. So what we're finding is how to define it for evidence purposes. So I'm telling you, over the next 10 years, you're going to see a huge number of cases. And what I have seen now, from 1998 when I started this to the present, is they never had text. They never had social media. And now we're seeing it is that kind of stalking behavior by way of social media.
I have to tell you, I'm way too afraid to get on one of those. I would
I
just way too afraid.
Of course, being the attorney, I focus on the legal aspects and education. But somebody comes in for an ex parte hearing. What is the standard that they have to prove? What level of I'm scared do you have to prove?
Can I add to that? Does there have to be a bruise?
No. You don't need to have visible injuries. Okay? You don't even need to have any injury. If the perpetrator goes after the victim and the victim ducks, that's still an attempt. So that could still be domestic violence. But you look at it in light of a history. Is there been a history of some kind of action? And the standard is immediate and present danger.
So,
And
like
that's
a so a
statutory.
new threat with past behavior would
Oh,
work, okay?
okay.
So that's what we're trying to say, that this past behavior, people who are, are victims of coercive control aren't necessarily battered every week. They,
Right.
something bad happened and just a threat or a periodic beating is enough to keep them in line. And again, if you have to think about the victimology here, you're talking about
Fear.
somebody who's fear, who has been isolated though. So we hear it all the time. I wasn't allowed to talk to my parents, my siblings. We didn't go for holidays anymore. I didn't
Had to
have,
know where I was at all times.
Right. I
Yeah,
had to check in
right.
with this person. I wasn't allowed to work, or wasn't allowed to have a car, or I had a job, but he drove me to and from the job. It's all these other behaviors that are isolating, and so that this person, as we were saying before, their norm gets to be narrower and narrower, and it's a
But
different.
let me just say, generalized fear cannot get you a protection order by all the case law. You can't go in and say, I'm afraid. Now, you can go in and say, he has hit me in the past, and now he's controlling everything I do. So the court looks at the hit, they look at the time frame between, they look at what the recent threat is, there should have been a recent threat. Then they hopefully look at the context. They look at that isolation, they look at everything that the judge said, they put it together, and then they would grant that protection order. At the full hearing stage, they also have to show an act took place, but they also have to show that they are in continued danger of domestic violence.
So how does that work when you have a trial and you have the both people in the same room? Does it get kind of nervous in there?
It's very difficult, and so one of the things that we've done, and the reason that we have the magistrates doing the hearings and we have the department, is that we've put everybody literally in the same hallway, and we have, I don't know, I think we're up to 20 or 21 cameras now. So there's
You
cameras.
have cameras in the hallway?
Oh yeah, and in all the rooms. In
No
all the
kidding.
rooms. Yes, so that everybody knows what's happening, because when we first started, what we found out was people were being coercive in the hall. They would, they'd give a look.
I've
look,
heard that a
right?
lot.
They would text, something nasty. So we take away the cell phones during the hearing. We make sure that people are separated. We have a safe room. We have 2 safe rooms in case there's a reason not to have the people different. We have to separate the people in the safe rooms.
Right.
So you'd have somebody in a safe room while the trial was actually going on?
No, they would just be there until the trial starts. Once the trial, everybody have the right to be in the room. I mean, it's certainly
But
possible.
the advocate's also there
Yes.
with the
Yes.
alleged victim.
Yes, by
Do you have
statute.
security?
For support, and it's going to be okay.
By
If they're right.
statute.
What about
they are
security?
allowed
The
to
person,
accompany.
the chairs can be such a position so you're not really looking at the person. We try to be very aware of the body language.
Yeah, because people can be intimidating.
Yes.
Just the look, you know.
But you know how, in a way, that's why the magistrates and the courts are also trained, because if they're sitting up there, they're watching, they're looking, they're seeing gestures, and they're able to assess, because they're assessing credibility, but they're also assessing for domestic violence. But they could see, depending on what's presented, how that victim responds, how that perpetrator or respondent acts. You can see both of those.
Are there security guards in the courtroom?
Well, the court has sheriffs. There's sheriffs within the building.
Is there more in a domestic violence trial?
Well, yes. Oh, absolutely. If there's a risk, and that's again another reason that sometimes that lethality assessment comes in handy, because the advocate knows what the score is, literally the score of the test.
Yeah.
And if they feel that there's a threat, then we make sure that there are deputies. And often the trials occur on the 3rd floor in the bigger courtroom, so people are separated more. So we have the ability to move people in the building to a different place so that there's more space, and so the deputy can be present.
Are those tests, the evaluations, available to the respondent or the respondent's attorney? Because obviously the court has
Well, the court
access
doesn't
to it.
have them.
The court doesn't have them.
No,
Okay.
only the advocate
And they,
Okay.
remember, they are not staff
of the
members
court.
of the court.
It's not in the court.
They just
so nobody
staff
subpoenas
the
it,
court.
or it's
But there's, I'm sorry, go ahead.
it's irrelevant to the. It's only relevant to the advocate, is what I'm saying.
It's relevant to the advocate and the victim.
That's
But
the
you don't
piece.
use it in the
That's-
trial.
It's
Right.
relative to the victim. If a victim, if they answer these questions, and then when they're weighted and scored, they're high risk, the advocate tells them, you're at greater risk. So how
Okay,
can
but
we
that's the only place that belongs.
At this point, yes.
Okay.
We've talked about whether the court should know about it, whether whether the advocate could come in and testify that the person scored. But remember, it's a self-test. The person is answering these questions. It's subjective. So, the questions are pretty concrete. Like, were you physically harmed during a pregnancy? That's a yes or a no. But again, it's the person self-reporting.
Where this is really would be helpful would be so after you finish with the protection order, if you were planning to get a divorce, then now you go to different magistrates and you have all the issues regarding a divorce. One of those issues is custody. DV may come up as far as custody of children and whether that parent is bad or is a good parent. So I have often wanted to bring in potentially the results of those reports because I think it could help educate the court on those lethality factors and that there are certain victims that would not be safe, meaning their kids would not be safe either.
Right.
So it would just depend. We haven't done it yet because there are evidentiary issues.
All right, well, it looks like we have a telephone call?
No, I'm trying to say it's already 1:30. We're just talking. So I know you guys are enjoying our show. Don't forget, you can call in. The number is 216-298-1554. This is a great chance to talk to Judge Palos and the senior attorney from Legal Aid who specializes in this, and Alexandria Ruden. So don't forget, phone number again, 216-298-1554 for your questions on domestic violence today.
So you do have a question here from Joe. He said, can you talk about a CPO request against a family member that lived in the same household in the past?
Who would like to take that?
Well, so we do have a lot of those cases. The ones that aren't intimate partner violence are siblings. We have an awful lot of cases around aged parents. So the parent is dying, is in hospice, or
I didn't know that's brand new to me.
I know. I was sitting here with big eyes listening to this.
Oh my gosh, that makes sense.
Right, they're family members.
Okay.
Right.
So
okay.
we have had fights at the funeral, fights
Wow.
at the deathbed, fights
Wow.
over the inheritance, the estate. Yes. We also unfortunately have what they call in England granny bashing.
What's that?
Elderly parents being beaten by their
Abused
by their children or grandchildren. Usually if there's drugs or alcohol involved, they're looking for money. So that's a really terrible thing, and it's those some of the stories you hear there are horrific about hurting old people.
It also includes foster parents. So if foster parents are beaten by their foster children, they can come in and get a protection order as well by statute.
Don't you just give the foster child back?
Well,
here you go.
Yes, of course they
An
can.
adult foster child. So what we want to point out is that you mentioned about juvenile court before. Juvenile court does have CPOs, but they're only if the batterer, the alleged batterer, is a juvenile. So if a foster child who was actually a child was beating up their foster parent, they could get a CPO against them and obviously give them back, but maybe there's no place to give them back. I don't know how that works. Maybe you can't give them back right away. I don't know.
But back to Joe's question, family or household member includes people who reside or who have resided with the respondent or the perpetrator and are related by respondent or the victim and are related by blood or marriage. So any other family member could be included, brother, aunt, uncle, as long as they are residing or have resided with that respondent.
So there has to be a family aspect of living together, because we were just talking about dating aspect.
And that's a whole new part of the statute, but it's its own part. It's family or household members or dating relationships.
And household members could be two people renting together. It could be, if you're living together, you're sharing a condo.
I apologize.
That's okay. That would fit.
This is the one time I get to cut you off for a second. If Joe is still on the line or listening, I think he's asking if there's no family relationship. If Maryann and I said, hey, let's share an apartment together.
Yes.
And 12 months go by. 12 months go by, and...
But no.
No, that's okay. What are we talking about?
roommates were not intended to be part of this statute.
If they were in a
it was intended for relationships, meaning you have a relationship with your parents, but not your roommate. This statute was not designed to cover. If they're dating,
that's a relationship.
That's of an intimate or romantic nature.
So it could be a same-sex relationship, right? It's
yes,
a relationship.
Absolutely.
But we'd have roommates coming down trying to file.
And those, just like you live with somebody for college, those were not people that were intended for this statute.
So they might go to civil
court
to get a civil stalking protection.
Gotcha.
Where could people who are interested in knowing what the legislation actually says, where can they find this?
They can probably just put in the internet RC 3113.31, and that will come up. Like a law writer will come up.
I mean, but any type search, domestic violence, Ohio.
You could do
You know
it.
what's so hard though is
things.
when you tell people do an internet search, they can come up with all kinds of answers.
But that's the statute.
And then in many states and countries.
Well,
right.
And it gets back to how Alexandria started this, talking about that there's different kinds. There's a social definition, and so when you Google it, you're going to sometimes find articles about the social aspects of domestic violence and things by social workers and things that are a different ilk than what does the actual statute say. And then the issue, and David understands this with law, is that the statute can say something, but how does the case law interpret it? On its face, it may think it means one thing, but it may mean something else.
Very complicated.
No, I'm learning a lot today.
Yeah,
myself.
me too.
I'll give you an example. We have one of the groups covered are persons living as spouses. Okay, who are those people? They are people in a common law marital relationship,
Which ended September 9th,
wait. Common law marital
1973,
relationship. Those people who are cohabiting are those people who have cohabited within 5 years prior to the act of violence. Now, Ohio no longer has common law. But if you entered into your common law marriage prior to September of 1991, you are covered. If you entered into a common law marriage in another state, we have full faith and credit. So common law marriage can still be included.
Wow.
And then the Supreme Court, what is the definition of cohabit? So the Supreme Court advanced in a case called State versus Williams in 1997, and I say the Supreme Court of Ohio, a definition of cohabit. And cohabit doesn't necessarily mean the exact living circumstances as it means the nature of the relationship, the degree of commitment between the parties. That's what we're looking at, and that's why just roommates themselves do not have that same degree of commitment.
So this area of the law is still changing.
Yes.
Is what you're informing us. Judge, there is, we had talked before we started, there's a seminar that you're going to in New York tomorrow.
Yes.
Right? Could you tell us a little bit about what that is and what they do?
Sure. So the National Council of Juvenile and Family Court Judges has a domestic violence section, and they are involved in educating judges and courts around domestic violence issues, and they obtain grants and do projects. So this is a grant project. It's called the Judicial Engagement Network, and this is the first year that they asked for applications for judges across the country who wanted to become a Gen Fellow. So I applied and I was accepted. There's about 12 or 15 people maybe on the list. And
so this is not a large group.
No.
Okay.
No. And so we're going to go to New York City to the Center for Court Innovation, which is running the program, and we're going to talk about projects that we're going to do. So one of the things that they asked us was, what would our project be? So we've been working on a project which is trying to get information, kind of creating a two-way street between the courts and law enforcement. So one of the things that we had a change in the law about service and notice, and not everybody knows about that. So we've been training around that, and we're also trying to make sure that we have some dialogue around firearm. We need firearm surrender policies, and we don't have those. And it would be really helpful. People who have a CPO against them are under firearm disability, and they're supposed to turn that firearm in for the duration of the CPO. The problem is we don't have a central place for them to do it, and that would be really helpful. So my project is going to be continuing to talk, moving out to as many police departments or districts as I can go to, and talking to the law directors and the prosecutors, and at some point trying to get a dialogue back so that we can create a repository. I mean, the county could take control of this and create a place where that staff, where the firearms could be turned in, and then they wouldn't be automatically turned back until we had a hearing to return them, because in that 5 years with the CPO, the person could have a felony conviction for something else, they could have another CPO. There may be a reason that they shouldn't get the firearm back.
Instead of just saying, oh yeah, you can drop off your firearm between 7 and 3 at the police station, maybe we'll have somebody there ready for you. So is it,
Right.
Are you looking, I mean, obviously this is just in the making, but are you looking more towards a central location or a couple central locations?
Yes, a couple would be obviously better for people, more would be better, or, at least east side, west side, or, south side, something like that. It could be a police station, it could be, other states have been really creative in this, and they have used a firearm range, because they already have lockers. They already know how to handle weapons. People are coming and going with weapons there. I mean, nobody wants somebody to walk into their police station with a weapon. I mean, you see that
Right.
that looks on its face bad.
Sure.
I mean,
Right.
there has to be a protocol around this. And what other states have done, like I said, they've either had this, like a fire range,
Or the dealer,
or
firearm
the firearm
dealer.
dealer could be a designated person. But if it's like the sheriff's department or
Yeah,
police
it sounds
station,
like
they're-
lots of civil liabilities
well, and so
all
there's
over the place.
protocols around this. So you lock your fire, you unload your firearm, you separate your ammunition from your firearm, you lock it in your trunk, you go inside, you say, I'm surrendering my firearms, here's the keys to my car, it's, a blue Chevy truck or whatever. The person sits in there, another officer goes out, gets the things, comes back in, logs them in, gives them a receipt, so that we're not having people running around with firearms.
Sure.
But there's all these protocols that other states have developed. We need to have that.
Other states have developed them, and because of our domestic violence department under Judge Palos, we really looked at thinking outside the box. So we began to create forms and looked at some kind of protocols on these weapons. So I actually had a case. She failed to turn over the weapons.
I was going to ask this question.
The ex went back into court on a motion to show cause. And we brought, she came to court and she said she had them. Well, the detective or the sergeant from the Garfield Heights Police Department also appeared because he was subpoenaed. And he agreed to take the weapons tomorrow, whatever day it was,
Sure.
between such and such and such and such. And she turned over the weapons. The biggest problem for police, absent a statewide policy, is that some don't want to do it. And then where are they going to store it?
Right.
And how long do they have to keep it? Because most protection orders stay in
Right.
effect for 5 years.
And when do they give it back?
And then how do they
So
get
that has
to
to
give
be
it
a
back?
lot of firearms.
Right.
It could be, yes.
So I had a show cause motion this week too.
I'm running mine.
So we've been doing, we've been trying to do this enforcement to make sure that the firearm is turned in, and if it's not, then somebody files a show cause, an affidavit, and a motion for contempt. So I had a gentleman, and he was picked up, and he spent a couple of days in the county jail, and he said to me that his cousin had the gun, and his cousin was a felon who had been arrested by the DEA, whatever. And so,
Who can't have a firearm to begin with
Right.
now?
Right. Well, but so anyways, he was able to produce a receipt from the federal agents describing that firearm exactly, that it was found under the bed at his cousin's house in a raid. So
Don't have
he
possession
doesn't
of
have it
it
anymore. He's fine.
But all those things are positive. We're
Right.
beginning a process, and I think the next piece is to create the same dialogue with the the feds, the U.S. Attorney in Cleveland, as well as ATF, and work together, because by federal law, perpetrators of domestic violence, where there is a qualifying protection order, they cannot have a weapon for the term of that protection order, period. We have not codified that into state law, hence why we're creating policy by policy.
Right.
Can I
So
go?
I'm sorry, go ahead.
Can I go one more step with that? File a motion to show cause. They don't turn over their weapons. Do they go to jail?
Yes.
And until they produce it, what if they say they lost it? Are they
Stolen.
just in jail? Yeah. What if?
You're not going to get everybody.
Sure.
And we don't have the ability to, I mean, there's nothing in the statute, I'm sorry,
That's
Judge,
right.
that allows the police to just confiscate the weapons. So we do not have that. So I think
It's difficult, and I think that normally if it's a civil contempt, then the law phrase is you have the keys to your jail. And when you produce whatever it is or do whatever it is you're supposed to do, you get let out. Normally, these sentences are for 30 days, and we haven't been doing this long enough that we've had anybody stay indefinitely that we actually thought had weapons. But the truth is,
So it really doesn't happen that much.
no. Well,
Yeah.
we've just started doing these in the last year or two. But here's the thing. It's not necessarily the person. The person's in jail. They get picked up on a warrant, and they're in jail. And so somebody in their family shows up with a firearm to get them out
Wow.
of jail because that's what
Wow.
they have to do. So it's just like anything else. And I mean, is it effective? It's more effective than nothing.
is
Sure,
it perfect?
right.
No.
Yeah,
Right.
if we
But
leave
it's
somebody in
good.
jail,
Right,
like Cuyahoga
nothing's
County
perfect.
Jail indefinitely, at this point in time, no.
I think the hardest thing is when the petitioner can describe the weapon and describe all kinds of things about it, absent the serial number, and then the respondent comes in and says, I don't have it. I never had this weapon.
But one of the things you can do, you could swear that person in, take it under testimony, under oath, that they don't have that weapon, and then at some point, if they're found with that weapon,
We always thought
SOL.
the prosecutor could do
prosecutor
something,
might
right?
be able to do something that could get, be a perjury issue potentially. I mean, we're just trying to come up with ways that we think would make, make people comply, because having a weapon is, again, one of those high risk things, and it's multiplied. It's not just like on the lethality assessment, it's not just a 1, it's a 1 plus 4, I think. So, and I wanted to say this to you, David, because you brought this up before about, I could hear your defense attorney brain going about the lethality assessments. When somebody in our court used to do them, the first year or so, there was the case manager used to do them. 75% of them scored in the lethality range. There were 50% were like, I don't know, it's like 20 points or more, which is really dangerous, and another 25% were, 15 points or more. I mean, if you're at 8 points, you start to be in danger. We're seeing 20s and 30s.
Oh.
Right. So it's, as a defense lawyer, you don't really want to have that admitted into evidence.
No, you don't, but
it's not gonna help
from
you.
a defense standpoint, if I know that the person's saying I was hit when I was pregnant, be like, dude, what did you do? What's
Yeah.
going on?
Well, and so
Is this true?
one of the things that we actually have been able to, I think, been kind of effective with is, so Alexandria was talking about, they come upstairs and they have a custody case. And there's a lot of times the DV is pending at the same time as the custody case, the divorce with the custody. We've been successful showing the respondents' attorneys some of the information, the advocate talking to that person, so they know that their client
Is saying what
is-
they're saying.
right. And I think that's sort of, it's educating to the attorneys, because the attorneys don't, unless you think about it and you really have it explained to you, people don't, it's not in their norm. And like the strangulation, we brought in a national trainer a few months ago under a grant from the Supreme Court, talking about strangulation, which again is one of the weighted things on the lethality assessment. If somebody puts their hands in their neck, we call it the last step to murder, because within less than 4 minutes you can kill somebody if you
Right.
put your hands around their neck. In as little as 4 seconds, they can pass out. And so the police officers come and the person says they don't remember what happened. And they don't, so the police officer, they don't remember what happened. Well, they don't remember what happened because they passed out. They wake up on the floor. They may have soiled themselves. They don't really remember. And the marks don't show up sometimes for 48 hours.
And sometimes the marks are internal, so they wouldn't show up. But
Wow.
another way of saying what Diane said was that if you're holding somebody by the neck and you're impeding their airflow, what a sense of power you have. You have that ultimate power over life and death. Hence why strangulation is such a precursor to
And
death.
statistically, it's like the people that are murdered have been strangled at some point in the past. High percentage.
Wow.
But you know, one of the other things that we're doing with the whole idea of domestic violence is the judge and I, and when we had Monica, who was the case manager, we did a lot of training on parenting and domestic violence, looking at the best interest factors and looking at them relative to domestic violence and how you would look at a case so you make certain that the right parent is the parent who is going to, for a better word, get custody. Not every case would do well with shared parenting, especially if there's domestic violence, especially if there's coercive control. So we've been doing a lot of training, both to lawyers. We're going to be training custody evaluators for the Supreme Court. And the Supreme Court itself created a document on the allocation of parental rights and responsibilities in domestic violence cases, considering the lethality factors, the best interest factors, and what type of parenting plan for cases in which there is domestic violence.
Interesting.
In the best of all possible worlds, there should be shared parenting.
Right.
But when there's been domestic violence, you have to assess and differentiate what that violence is. You know, and is it that bad act because the marriage is breaking up that never happened before? Or is it this coercive control that is pervasive and has the person literally shaking uncontrollably, you know, or somewhere in between? And you have to then look at the parenting, because if you have this person who can't physically look at the batterer without falling apart, they shouldn't be present at the exchange of the children at a minimum.
I
They
so
definitely-
agree
they
to that.
definitely can't talk to each
Right.
other
Right.
about what's going on
So
with the
you
child.
need, so there's different levels of, you know, do you just have exchanges at a different place, or, you know, is it so bad, have the events been so bad and the children been traumatized by them that they should have supervised possession time, or even no possession time until there's therapy and something else happens?
Judge, as far as pickups and drop-offs, is there a place that you prefer, or is it all based on circumstances of the case? Like, I know in juvenile court, well, exchange at the police department,
Yeah.
or exchange at the
So
library. Is
here's,
there?
Here's the big secret about exchanging at the police department. The police aren't in the parking lot and they don't have cameras.
There was a murder, 6 weeks ago, somewhere in the state of Ohio, I think,
In the
that they
parking
were
lot,
transferring
yes.
a child in
Right.
the police parking lot. I'm
Right.
watching it like,
And so
whoa.
this is like a big fallacy that it's safe. The library might even actually be safer because people are
Right.
coming and going.
Or you do it in the waiting room of the police department.
It has
but
to be,
you can't
but
do
you
it
have
in
to
the
tell them
parking
that
lot.
you're doing this,
Yes.
and so
Yeah.
you have to sort of make friends with them and make sure that they're going to let this happen. So, you know, the best place would be supervised visitation center.
Yes.
You know,
Safe and sound.
Safe and sound.
Speaking of which,
Speaking of
there's
which,
another one besides Safe and Sound.
Yes.
yes.
Maryann, do you know of any other place besides Safe and Sound?
I sure do. You guys know about our program.
Yes.
We have the program too. And we just had a big conversation a couple weeks ago about they want to do supervised visitation. There was a DV, but something happened and it was remanded or whatever happened. So there's no DV in place, no protection order, but still I did not feel safe having these two parents in the same orbit. Supervised visitation, one parent drops the child off, you leave.
Right.
The other parent comes. There is no interaction. You know, even if I think there's a problem.
What about if the dad? I'm assuming the domestic violence abuser, alleged abuser, is a father.
For our purposes.
For our purposes,
Right.
He, she,
well,
yes.
it
let's
could
be
be the
real.
mother.
It's
Not always.
it's usually
Not always,
a
not
male.
always,
I
but
get
yes.
it.
Yes.
Right, Black Widows on 2020 next Friday.
Okay.
So, but anyway, typically it's the man, yes.
Marion, let me tell you this. Like, I was on the committee for the Safe and Sound, and the federal regs on this are really clear that there has to be 2 separate entrances, 2 separate parking lots, 2 separate times.
Thank you.
For this to be safe.
Is
And
this what you
so-
told me to look up? Because I forgot to look that
I
up.
think so. So
I will look
that's
that
what you
up.
really want to be careful about.
I'm very
I've got a
insistent
case
on that.
where I got a case where I don't want to talk about it, but there's concern that he's going to show up early. He's going to hang around the place or have a set of eyes. You know, where this child is going to be dropped off. How does that become that safe?
Well,
I mean, because you know when the child's going to be dropped off. If the visitation's scheduled for 1:00, you know at least maybe a half hour beforehand the person's going to be right outside or down the street.
They try to stagger the times. They try to, all we're doing is the best we can with what we have.
No, I understand. I'm just saying
So,
that there's just so
I
many
know.
still problems with it.
For our clients, what I would do is, again, we have a 15-minute buffer. It is optional, but most of the time we implement it just because anybody who's in this situation has a tumultuous relationship. So yes, there's a 15-minute buffer. If they're driving from a long way, I'll have one person park like at a Sunoco down the street that way if the other parent is coming from that way. And then this parent comes this way. And then I call the other person when this person leaves. But I think you're hitting more to what happens if they just flip a lid and.
I'm sorry, I'm thinking like alleged batterer.
Well, hopefully this will never.
If I wanted to violate
it will never happen.
The thing is that it's like anything else in the world. If somebody puts the effort into breaking the system and doing the wrong thing, they can. I mean, you know, that judge that was shot in the parking lot on his way into court last year, you know, thank goodness the bailiff was there and they shot the person who shot him, and the judge, you know, is fine, he's recovered. But somebody who wants to do something like that, I think it's difficult, and that's one of the reasons I think the underlying message, we haven't said it yet, but I think it needs to be said, is that when these laws are enforced across the board, from the police to the court, from everybody in between, when everybody follows the rules, people are safe. It's when somebody... And
that's why you're there.
Well, of course,
somebody's not following the rules of society.
But I don't mean just the respondent. I mean if the police don't serve, if they don't...
Every part of the system.
Every part of the system has to work. You know, so if people understand that they're, you know, the police ask for their gun, the police are telling them to leave the house because they've notice of the order and they need to leave. You know, if everybody does everything they're supposed to do all along the way, you have a better chance.
Well, one last question, just because I defend some of these. What recourse does a gentleman have that I've been in on final hearings where it's just like, you just don't want this guy to be around your kids. You just want to take the kids. You're just alienating him.
I can't believe
and
it
just
took
sitting there
57
going,
minutes for this to come up.
There's a big difference between
I tried to do that.
alienation of a child and protective parenting.
Yeah.
And hopefully I would look to the jurists to hopefully help us figure that out, or family evaluation or something. And what I do with my clients, representing mostly victim mothers, what I would want to do is, my client needs time. He abused her. She's afraid for her kids.
Maybe.
Maybe
he abused her.
And that's hence where it is. I cannot make that piece better. But I usually say to the other side, if my client has some time to learn to trust again, then and your client can just go with the program, many times it's very workable.
We've tried very hard with a lot of different ways to get people to do what they need to do, the work they need to do, so that they can see their children. And again, I talked about differentiation of the kinds of domestic violence. We also have to talk about differentiating the kinds of parents, because some parents only want a real batterer sometimes only wants the kids because it's one more power play. So, you know, and you're saying, well, what if the person isn't really a batterer and it's made up? Okay.
Well, yeah, I mean, I hear my clients, you know, they get all the support in the world. They've got domestic violence advocates. They got this, and you know, even if they don't have money, there's no low income defense attorneys to help me defend this case.
There is a public defender on a contempt.
I'm just talking about originally where we show up and you just drill all these holes.
Under VAWA, all of the funds had to be used for the victim until recently, and I think that there's been a little bit.
I remember that.
There's more things about batterers intervention happening now, and other ways to treat other issues.
But the dilemma you have, they have to admit they're a batterer.
Yeah.
If your clients are not
that's what I'm saying.
Yeah.
I mean, I got people like, I didn't do anything to her, you know, or she started swinging at me and I just happened to have had a stronger arm when I hit her and I left a mark. She didn't leave a mark and now I'm screwed. And that's a great place to end.
And I can say, oh well.
Oh, sorry. I was hitting the table. It was my turn to get a little feisty.
I was wondering what the look was. Okay, we got 1 minute. I want to thank everybody for joining our show. Thank you so much for your time and expertise. Good luck with your conference tomorrow.
Thank you.
We look forward to more great work with the domestic violence. I just have one quick question to slip in here really quickly. Both of you, if you could just say, do you think that the domestic violence has escalated in the past 20 years, yes or no?
I think domestic violence is more visible. And I think
That's it. That's
Yeah,
a good
no,
way
I-
to put it.
because
agree.
of I think it's just more visible. I think it has always existed. I don't think it's escalated anymore, but it is more visible, and there are more victims of violence who are coming forward.
More
Okay.
education.
And
And
our
more
case,
education.
our caseload
And that's
has
our
doubled.
show for today. Thanks for watching Family Court Secrets. Do we have a second left?
Have a good night.
No, we're